Title VII of the Civil Rights Act of 1964 requires employers to make reasonable accommodations for employees' religious observance or practice. Is any reasonable accommodation enough, or must an employer provide an employee's preferred method of accommodation? The United States Supreme Court wrestled with this question in Ansonia Board of Education v. Philbrook. Ronald Philbrook was a high school teacher employed by the Ansonia Board of Education. Philbrook belonged to a church that prohibited its members from engaging in secular employment on certain holy days. As a result, Philbrook missed 6 workdays per year. Ansonia's leave policy allowed employees to take 3 days of paid leave annually for religious purposes. In addition to these 3 days, employees were allotted additional paid leave for illness or personal business, but this time couldn't be used for religious purposes. Philbrook repeatedly asked to use personal leave for the 3 remaining days, or, in the alternative, to hire a substitute if Ansonia agreed to grant him 3 additional days paid leave. Ansonia refused both alternatives, and instead allowed Philbrook to take 3 additional days per year of unpaid leave. Philbrook sued Ansonia, arguing that it had failed to reasonably accommodate his religious beliefs. The district court found for Ansonia, reasoning that it hadn't forced Philbrook to choose between observing his religion or losing his job, so he hadn't suffered religious discrimination. The Second Circuit reversed, holding that Philbrook had established a prima facie claim of religious discrimination and that Ansonia had to accept Philbrook's proposed reasonable accommodation unless it caused the school board undue hardship. The United States Supreme Court granted cert.